In this case, none of that happened. So the trial guy violated the right to a hearing of the applicants. Now to our orders. We have taken note of the fact that the applicants did not contend that there had been earlier completed collations in respect of the Sawam Adwajiri and Ahafano North constituencies per paragraph 8 of the affidavit sworn to by the affidavit dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to the quash are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies. 1. Okai Great Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Afano North are not affected by this order, by this our order, and in effect, those declarations stand. Despite questioning the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined. In line with our conclusion on this application, we exercise our powers under Article 1294 of the 1992 Constitution and make an order pursuant to Order 55, Rule 65, to the effect that the applicants herein are granted leave to file affidavits and statement of case in answer to the respective applications for mandamus which have not been quashed. No, which have not been quashed. Those which have not been quashed. They are still extant. Those which are quashed. Yeah. But those which have been quashed. Those which have been quashed. Yes. They go to file those which have been quashed as interested parties. The time for filing is hereby abridged to 2 days from today. The applicant for mandamus in the High Court upon service may respond to the processes of the interested parties. Having regard to the circumstance of time constraint on the national electoral calendar, we hereby abridge the time for a hearing of the mandamus applications in the High Court and direct the High Court to hear the applications for mandamus on Tuesday, 31st December 2024. I hope Tuesday is 31st. On the issue of bias, we are not satisfied that sufficient evidence has been provided to us by the applicants. Nevertheless, in order to maintain the integrity of the adjudicatory process and in line with the practice of this court in cases such as Republic versus High Court ex parte Adwa Company Limited, Auditor General, Interested Party, 2019-2020 Supreme Court Law Report of Ghana, Adare. We hereby direct that the applications for mandamus that are extant shall be placed before a different High Court judge for hearing and determination. To conclude, by the conclusions reached in this decision, readings A1, A2, A4, and A5 endorsed from the applicant's motion paper are hereby granted, while readings A3 and A6 are refused. Readings B and C are hereby dismissed. Ordered accordingly.
My Lords, we are extremely grateful, extremely grateful. We are grateful to the court. My Lords, we are grateful.